Hi there, I'm Jenna Layton, the Vice President of Legislation for SDSHRM, and I'm back with another legal update. Don't forget to check back every month as I'll be bringing you the most current information that you need to know in order to be up to date on the legal issues that are affecting California's employers. Let's start out with this month's legislation update. First and foremost, the California Senate has passed Senate Bill 1349, also known as the Social Media Privacy Act. This bill would prohibit employers from requiring or formally requesting in writing a current or prospective employee's username and account password for personal social media accounts, or otherwise requiring the employee to provide the employer access to any content of those accounts. The California Assembly is also considering Senate Bill 491, which was previously passed by the Senate and which would invalidate any provision in a form contract entered into on or after January 1st, 2013, which proposes to waive the right of one of the parties to the contract to pursue a class action, class arbitration, or a private attorney general action. This rule would apply broadly to most employment contracts, including arbitration agreements. If passed by the Assembly and signed into law, this bill would create some uncertainty for California's employers in light of several recent judicial decisions upholding class waivers and arbitration agreements. We'll keep you posted on the status of these bills as they move through the legislature. Let's move on to our judicial update. This month, the U.S. Supreme Court ruled that pharmaceutical sales representatives are exempt from overtime under the requirements of the Fair Labor Standards Act. The plaintiffs, two sales representatives of a large pharmaceutical company, sued their employer, alleging that they were owed overtime wages pursuant to the FLSA. The pharmaceutical company argued that the sales representatives were not entitled to overtime wages because they were classified as outside salesmen. The FLSA requires employers to pay employees overtime wages, but this requirement does not apply with respect to workers employed in the capacity of outside salesmen. In the past, Congress has not elaborated on the meaning of the term outside salesman, but instead had delegated authority to the Department of Labor to issue regulations to define this term. In this case, the Supreme Court ultimately held that the Department of Labor's previous interpretation of the exemption, which was that pharmaceutical sales representatives are not exempt because they are not primarily engaged in sales, is A, entitled to no deference, and B, has no persuasive value. Examining the exemption itself, the court found that pharmaceutical sales representatives are primarily engaged in sales, which includes any sale, exchange, contract to sell, consignment for sale, shipment for sale, or other disposition. As such, these individuals are exempt. Turning now to California courts, we've got another win for California's employers as the Court of Appeal has upheld an arbitration agreement containing a class action waiver. The case is known as Iskanian v. CLS Transportation, Los Angeles. In this case, a wage and hour class action complaint was filed in 2006 by a driver whose contract contained a requirement that claims be arbitrated individually. CLS Transportation's lawyers moved to compel arbitration. The lower court granted the motion in March of 2007, but the Court of Appeal, on its first consideration of this case, remanded to the lower court in light of the California Supreme Court's August 2007 decision in Gentry v. Superior Court. Gentry held that an arbitration clause's class waiver should not be enforced if class arbitration would be a more effective way of vindicating employees' rights. Following the remand, CLS Transportation voluntarily withdrew its arbitration request. However, after last April's ruling in Concepcion v. AT&T Mobility, wherein the U.S. Supreme Court held that the Federal Arbitration Act allows parties to limit arbitration agreements to single plaintiff claims, CLS Transportation decided to revive its motion to compel arbitration. The Iskanian court held that the Concepcion decision conclusively invalidates the Gentry test. The court said that a rule like the one in Gentry, which requires courts to determine whether to impose class arbitration on parties who contractually rejected it, cannot be considered consistent with the objective of enforcing arbitration agreements according to their terms. The U.S. Supreme Court's decision in Concepcion and the California Court of Appeals decision in Iskanian provide new hope for employers in California who are faced with a deluge of class and/or representative actions. Based on these recent decisions, California employers may be able to enter into binding arbitration agreements containing class waivers. However, the efficacy of the Iskanian decision may be short-lived, as the decision will likely be appealed to the California Supreme Court. In contrast to its decision in the Iskanian case, the California Court of Appeal held in Hoover v. American Income Life Insurance Company that an employer waived its right to compel arbitration by first litigating in court. The plaintiff in this case worked as a sales representative for defendant AIL, a Texas-based company that sells life insurance policies in California. Pursuant to a collective bargaining agreement governing her relationship with AIL, the plaintiff signed an agent contract stating that she was an independent contractor, not an employee. The agent contract also contains an arbitration clause requiring the parties to arbitrate disputes relating to the agent contract if they were unable to resolve the disputes informally. The plaintiff in this case terminated her relationship with AIL voluntarily and later filed a class action complaint against AIL, alleging that AIL had actually hired its agents to sell insurance as employees and had failed to reimburse them for business expenses, to pay them minimum wage during training, and to pay them earned wages due after termination. The parties actively litigated the case in court for 15 months. Thereafter, AIL filed a motion to compel arbitration based on the arbitration clause in the plaintiff's agent contract. The trial court denied the motion to compel arbitration, ruling that the plaintiff's statutory wage claims are not subject to arbitration because neither the arbitration agreement nor the plaintiff's collective bargaining agreement referred to the arbitration of statutory rights, in other words, labor code claims, and because AIL had waived its right to its participation in the litigation process. The Court of Appeal affirmed the decision, holding that AIL had waived its right to compel arbitration by actively litigating the case for more than a year. The court further held that the statutory wage and hour claims were not subject to arbitration because there was no clear and unmistakable waiver of a judicial forum for those claims. AIL argued that the plaintiff agreed to arbitrate her statutory wage claim under the agent contract. However, the court stated that AIL failed to point to any contractual provision under which the plaintiff expressly agreed to arbitrate any violations of statutory rights. Instead, the language of the agent contract merely described its scope as applying to any dispute or disagreement arising out of or relating to this contract, and all disputes, claims, questions, or controversies of any kind or nature arising out of or relating to this contract. According to the court, nothing in the contract constituted an express waiver of the right to a jury trial with respect to the enforcement of statutory rights. The court noted, however, that in cases where the parties are engaged in interstate commerce, the Federal Arbitration Act may preempt state statutory claims, in which case an employer could compel arbitration regardless of the contractual language. This case highlights the value of preparing a comprehensive employment agreement that includes a valid and binding arbitration provision whereby the employee agrees to arbitrate claims arising from both statutory and non-statutory rights. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshRM.org. Additionally, I again invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at 858-509-5696. You can also email me at jleyton@petitcone.com. That's JLEYTON at PETTITKOHN.com. That's all for this month's legal update. I'll be back next month with more of the information that you need to know.